Thank you for joining us for another episode of Baker Host's Ad Nauseam, a podcast series focusing on new and trending advertising issues with an emphasis on the FTC and the NAD. I'm Connor Corbett, your new host for Ad Nauseam, and you're listening to Baker Hosts. We are once again joined by Amy Mudge and Daniel Kaufman, two partners from Baker Hostetler's advertising, marketing, and digital media team. Together, they have decades of advertising experience and approach advertising issues from multiple perspectives. On today's episode of Ad Nauseam, Amy and Daniel are back with national treasure and all-around great person, Lesley Fair, a legal expert, distinguished law professor, and former senior attorney at the Federal Trade Commission. In their two-part interview with Lesley, Amy and Daniel discuss her experiences at the FTC, memorable cases, and what she thinks of the current legal landscape. With that, welcome to Ad Nauseam, and let's turn it over to Amy, Daniel, and Lesley for part 2 of You Have Lesley Fair Notice.
Welcome back to Ad Nauseam, and we are kicking off part 2 of our discussion with the one and only Lesley Fair, consumer protection professor and one of the most famous and beloved FTC staff attorneys of all time, known for her time as a fierce enforcer in ad practices, and then as a stalwart of business education, teaching companies how to comply with Section 5. I know in part 1, we talked about some old school important advertising cases, but today we are going to switch gears.
Yep, let's first go back in time. And you know what? We're not even going to waste time with pop culture, looking back, oldies, favorite things. We are going to have, I don't need to procrastinate. We are going to have so much fun today digging into some history. Lesley, how did you end up at the FTC?
Well, Amy, my real hope is that this podcast is kind of like Godfather 2, one of the rare ones where the sequel is better than the original. But we're also kind of going to go back to the origin story, and that was part of Godfather 2 also. The first thing was I grew up as an Army brat, and so I grew up watching companies charge 18-year-old soldiers on their way to Vietnam 300% interest on a Camaro, and watching my parents attempt to deal with that, with those kinds of really egregious violations of consumer rights perpetrated against people serving their country. I also worked full-time during law school for the Legal Services Corporation, working on landlord-tenant consumer cases. So I got very interested there too. But I think what really did it for me, I had a district court clerkship right out of law school, and it wasn't until halfway through that my boss handed me a stack of resumes and said, go through this. And I saw all of these Stanford Law Review editors and Harvard moot court champions. And I said to him, why, Judge Shannon, did you hire me? And he had two great answers that have really stuck with me. He said, number one, I was in the middle of my class at my law school, and I don't want a law clerk any smarter than I am. I thought that was good advice. And second, he said, I want a law clerk like you who's going to come in every day thanking God they had this job, which I did. But after that, I went to be a visiting fellow at Georgetown's Appellate Litigation Clinic. This was a criminal defense appellate clinic. I got to work on Supreme Court cases. It was great. But one of the cases that I had a very tangential involvement with is called FTC versus Superior Court Trial Lawyers Association. This was in the early 80s that Superior Court trial lawyers, I think, were getting $15 an hour for representing indigent defendants here in D.C., and got together and said, we want to get $20 or $25 an hour, and we're not going to take any more appointments. You know, these are not D.C. hired public defenders. These were volunteer lawyers who wanted to be on there. And in the early 80s, the Federal Trade Commission sued defense attorneys trying to get $5 more an hour for in-court time representing indigents. They were sued. And I was not a named defendant in the case, but I certainly was on the other side as a member of the Superior Court Trial Lawyers Association. So that was kind of one of my first involvements directly with the FTC. But it also allowed me, when companies many years later would say, oh, we could never be subject to an FTC order, I would say, don't worry about it. I am. They sued me, at least in my membership capacity. The other final thing is I've always loved advertising, always. And I said to myself as a kid, I wanted to either be a lawyer or go into advertising. And so I think a lot of us at the FTC are like that. We love good ads. And I think that's why I think I had such a great job for 37 years.
Well, Leslie, I'm just so glad you didn't end up an antitrust lawyer. After that first exposure to FTC, thank goodness, it would have been an entirely different illustrative career. But, you had many, many years doing enforcement work in ad practices. But then you switched gears and you ended up creating the award-winning FTC's business blog. Now, before we talk about that, I just have to tell you that the content you put out there, and we're talking well over 1,000 blogs, was so incredibly helpful to businesses and consumers. And, clear, understandable takes on what the FTC was up to. You really conveyed what the FTC did and what industry should learn from recent agency actions. And you got companies on board. I know the blog's still out there, but I miss your voice. But can you give us a little bit of context about how the blog was born?
I had litigated cases for about 25 years in the Division of Advertising Practices, and the idea came up that perhaps there was a need for an attorney to be more active in business guidance and business education, outreach to business. We had put on about 25 conferences along with the Better Business Bureau, the State Bar, back then called Green Lights and Red Flags, FTC Rules of the Road for Advertisers. We drew 350 people in Louisville, Kentucky. Who knew? And we realized that there was a real hunger for businesses. It's not enough to say to a busy business person, go read the pleading. I mean, people like you and Daniel follow these regularly, but general practitioners, they want the basics. They want it clear. And so I had pitched the idea to my then boss, Carolyn Shanoff. She was a former journalist. And she said she was willing to pitch it, but it had to be interesting. It couldn't be one of these things with a Senate-confirmed appointee and 3/4 of an American flag in the picture in the background. David Vladeck, who was the bureau director at the time, a very courageous bureau director, to give me access to the agency's website, he basically said to me, the first time anybody says that it's a good blog for a government agency, you're fired. He said, I want everybody to say, I can't believe this is on a government website. So that's how it started. We finished up. I think I had written about 1,750 blog posts before I left.
Whoa.
And the goal, as we said, the line has always been a maximum of how-to and a minimum of yada, yada, yada. We wanted it to be fresh, to the point, and memorable. And thank you, David Vladeck and Carolyn Shanoff.
And I can hear David's gravelly voice when you say that.
Yada, yada, yada.
Right. But look, I would be remiss if I didn't point out that a whole bunch of your blogs are no longer on the FTC's website. When I last looked, there were about 770 of them online. Clearly, many hundreds are no longer accessible. So are there any thoughts you want to share on the disappeared entries? Were there some secretly subversive messages perhaps embedded in those disappeared blogs?
I did not nothing was spelled out in the first paragraph. People ask me where they went. I think they went probably where that 35% of calcium in the Kraft case went. I don't know. I left the commission in September of last year. Obviously, every bureau director and every chair decide these things on their own. I would simply say that I think there is a critically important role for an agency like the FTC to be as transparent as possible to businesses. I think the agency should not be a gotcha kind of place. When I was there, it wasn't. And I'd like to think it isn't now, that we have an obligation to be clear about what is expected of businesses.
Yeah, I have to tell you, Leslie, I have a partner here who will remain nameless. We told her you were going to be guesting, and she said this to me. And one, make sure you know that she totally fangirls over you. She's read your blog since day one and thinks your ability to take important legal concepts and explain them in a way that is understandable and interesting is a rare skill indeed, particularly for lawyers.
Well, I will again give great credit to managers and commissioners who were willing to take a risk. We didn't talk about National Pickle Week. These were substantive posts talking about important things. The one time even I will say I crossed the line is explaining the employment provisions of the Fair Credit Reporting Act, the FCRA, to the tune of YMCA. Okay, maybe that was a step too far. But generally speaking, I credit my reviewers, and the toughest one I had was Mr. Daniel Kaufman over the years, for the great work that they did to help me realize where that line was.
Not at all. Daniel, when he names our podcast, I think he tries to channel you in terms of picking awesome punny titles. And he tries, but
He does a darn good job.
but all of us feel that way. That partner did, that fangirls you. But hey, let's move on to the next topic. And I'm very excited this was my idea. I would like to talk about old, wacky FTC guides and rules. We spent a lot of our podcast last year talking about new rules the FTC was cranking out. Probably we won't have too many of those this year, but there were a lot of rules on the books. The FTC website has a lengthy list of all the agency rules and guides that have been eliminated over the past many decades. If you Google FTC retrospective rules, and you will find it. So over the years, I've heard you talk about the frosted cocktail glass rule. And I saw on that list that is indeed a real thing, which leads me to my first question. Why and what the heck?
Frosted cocktail glass rule is great because this was a product I remember. It was the one advertised late at night, especially around the holidays or around Father's Day. This is what you bought your dad so he could put it down in the Knotty Pine bar in the basement next to his Ham's beer neon signs and stuff like that. I guess it's called a man cave now. It wasn't then. And this would put that frosty rim around a beer mug or a cocktail glass. The downside, and it worked wonderfully, the downside, and this is a chemical that may come up later in our conversation, is that how it got frosty was a product called methylene chloride. And when methylene chloride wasn't frosting daddy's cocktail glasses, it is a known human carcinogen. And that was an example for what the frosted cocktail glass rule was all about.
So I know the rule eventually gets repealed, but my important question, if I do come across some antique 70s frosted cocktail glasses, should I not sniff them?
I would never offer you advice on what to sniff and not sniff, Mr. Kaufman. I will leave that to your discretion, but I think in the interest of your good health, probably not.
Yes, we all have got to work to keep Daniel on the straight and narrow. Thank you, Leslie. Thank you. All right, so that rule becomes obsolete. But can we talk a little bit about this in the broader context of when should FTC engage in Section 18 rulemaking? We look at the list of rules and guides that are rescinded, and frankly, it's kind of all over the place. We have guides for hosiery industry stuff. We have guides for advertising fallout shelters. And the rule on the advertising and labeling the size of sleeping bags. And I don't know if I can say this on a family show. We also had something on the advertising and labeling of previously used lubricating oil, which I hope was for cars. Any thoughts on how in the world the FTC ended up with all these incredibly specific rules and guides? And what is its guiding path? What should be that guiding path for the 21st century?
Well, the fallout shelter rule or the bomb shelter rule was always my favorite. First, how do you substantiate your claims if you're selling bomb shelters? Question one. And question two, by the time the FTC finds out that a company's bomb shelter did not survive a certain megaton bomb, we've got way bigger issues than Section 5, right? So I think looking back is a good reason why I think some of the rules were very specific and now look a little bit foolish. The interesting thing when it comes to these rules and these trade regulation standards, very often who wants to keep them are members of the industry. That when the FTC announces, listen, we're thinking of getting rid of this one because there's really no need for it, it's not unusual for trade associations to say, we want you to keep it on the books. It's a good guardrail for our members. I mean, not always, but it can certainly happen. I think a nice paradigm for the future was really the FTC's impersonation rule, which was one of the few rulemakings that was not directly congressionally mandated that was done during Shirley Khan's years. I thought that one was a really interesting one. I think we all are aware of these terrible impersonators that claim to be the Social Security Administration or Amazon or PayPal or somebody like that, or people's banks or credit cards, that really can be very persuasive and fooling people. I thought that was a really good one. Staff did that amazingly quickly following every step of the pretty complicated process that they have to under Magnuson-Moss rulemaking, which of course the FTC uses since Administrative Procedures Act rulemaking is off the table for them. But this one I thought was also important because who the injured parties were certainly were consumers. Consumers were losing hundreds of millions of dollars a year to these scams. But there was another victim of these scams too, and that's the companies whose names were being used and the government agencies whose validity and veracity was being undermined. So I thought that was a good example because it was carefully drawn, narrow in its scope, dealt with a problem that I think all sides of the political spectrum were in agreement with. One of the things that I think is troubling, and I learned this the hard way when it comes to what's kind of happening in the past few years and now, one administration, not at the FTC, but one administration spending time repealing the rules of the previous and then having the other thing happen. How I learned this is requiring my students to read the 900-page arbitration clause rule that the CFPB was doing, only to have them 11 days later, I think I forget if it was by presidential order or by act of Congress, undo the rule. And that kind of ping pong with every change of administration, I would suggest is bad government. I would suggest it's bad business. And I would suggest it's bad for consumers. And so that's one of my fears, that rulemaking that is not done in a bipartisan sense is more likely to have this ping pong effect that just is not a good way to run a railroad.
Great point. Leslie, I'm going to totally switch topics and I'm going to go out on a limb. I am confident that no one has ever fallen asleep while watching you present on advertising and consumer protection.
There could be a few people right now, but that's...
That is, well, we're used to that on Ad Nauseam.
That's us, not you. All right,
no, it's me.
From what I can tell, even sullen groups of angst-ridden college students have been captivated by your presentations. And I am sure most of our listeners have seen you in action. How do you do this? Are there any pointers you can share about best practices when you're presenting on these issues?
Oh, awesome question, Daniel. Thank you. Thank you. Holding breath, waiting.
I think the big one is that PowerPoint bullet lists are an abomination unto the Lord. Period. Even if you do have to give that kind of information, I once just Googled ways to convey information without using a PowerPoint bullet list and came up with amazing slides that I could crib. And especially for advertising, I am shocked at the number of advertising presentations that I have been to where the presenter doesn't show the ad. Isn't that what it's all about? You need to look at the juxtaposition, look at the colors, look at the quote-unquote disclosure that's in white on an ecru background. This is what we do is visual. And I think that in the area, especially of advertising, there's just no excuse for us not to learn from our very clever clients or defendants about how to make things engaging for other people.
Well, Leslie, how do you prepare for your presentations? I mean, you make it look so easy. You make it look like you're ad-libbing. It's completely natural. And a lot of times when really good speakers get there, it's because they've really rehearsed it to be able to present it in a way that's that conversational. Do you have any speaking tips for our audience?
Well, the reason it appears so spontaneous and ad-libbed is because I've been saying the same thing for 37 years. That makes things seem much more spontaneous. I think for most public speakers, fear is the driving force behind most bad presentations. They're afraid of saying something wrong, when really what you're trying to do is have a conversation as you would if you were sitting across the table from somebody. And listen, I've said some things, I've had a few blunders, said things that I probably shouldn't have said, but I think that's the price you pay for getting the message across effectively. And I think remembering that the people in the audience want to be learning from you, want to be hearing from you, and that there's just nothing to be afraid of.
Well, Leslie, I know you have a real gift for this, dating back many years, and that you were a debate champion from your Georgetown days. But you also shared with me you didn't get the top prize. And I was hard-pressed to think of anyone more gifted at gab and oral advocacy than you. So can you tell our audience what happened there?
Well, the one correction I will make, Amy, this was not a Georgetown. This was high school.
No. Oh my gosh.
Yes.
Okay. All right.
I was a T.C. Williams Titan, now called City of Alexandria High School. If you watched the movie Remember the Titans, that was my
Of
sophomore
course.
year.
And you're
And-
GW. What am I thinking,
Yes.
Georgetown? Oh my
So-
gosh. Okay.
Yes, so that's, and then of course, to call a Notre Dame graduate a
Yes.
Georgetown student.
I'm so sorry.
Thank you.
Please.
That's
I'm
another
deeply flawed
abomination
human.
unto the Lord, Amy. Watch out.
Yes. Yes.
But, the big competitor was at Yorktown, a great high school in Arlington. And I've said before, at one kind of speech competition, she won the big prize, which was a savings bond with a lot of zeros. I got second place, which was a Rand McNally Road Atlas that I kept on my desk at the FTC just to mock me, to remind me to do better. Of course, who beat me? It was Katie Couric, the former host of morning television. And my late mother, until her death at the age of 97, refused to watch the Today Show because she thought I was cheated out of that prize.
I'm sure you
Shutting
were.
me up has never been an easy thing for people to do.
That is loyalty.
Yeah.
Okay, let's go back 20, 30 years. Before the blog, you were, of course, a litigator for a long time in the FTC Division of Advertising Practices. I was lucky enough to get to work with you on one of my investigations very early in my career. I still remember 3 straight days of investigational hearings, or as other people call them, depositions, in New York. You were kind enough to have me do all 3 in order to make sure I got the experience. I remember also they were back to back to back, and I was ready to keel over by the end of it, but that's another story. But tell us about some of the cases you worked on that really resonated with you.
Well, I think the statute of limitations is run, Daniel, and I can give you the big reveal. I'll also say, as you remember, those were depositions defended by a very prominent former FTC personage. And these were, I think, your first FTC depositions. But there were 2 reasons why my choice was to have you doing the deposition. First, I'm kind of lazy. And second, and most importantly, I knew you would do them better than I did.
Oh,
And I was
please.
right. I'm not blowing smoke. You're not my boss anymore, Daniel. So yeah, I got no justification where I have to do that. You did them very well. And it wasn't a surprise for me to see you advance as you did through the FTC. The case that I would say was most memorable was perhaps one of the first ones I worked on, which was a case involving a water filter device glued together, you'll remember the phrase, with something called methylene chloride. I think comedians call that is that a callback or something like that? I mentioned methylene chloride earlier. And basically, Consumer Reports magazine found this high amount of this suspected
Poison.
human carcinogen in the product. And of course, as is now public, the FTC looked into it. The company said, listen, it was a problem. We took care of it. We had a national recall. Everything's okay. And the FTC decided in an exercise of prosecutorial discretion not to go forward. This is all public information, I'm telling you. Fast forward a couple years, and Consumer Reports magazine does another test and finds that yet again, the product is giving off this methylene chloride. The bad news is it's a probable human carcinogen. The worst news is it's water soluble. And this was a water filtration device. And the FTC brought the case that time. I worked on it with 2 FTC legends, Joel Winston and Jim Skiles. The interesting thing, one of my first jobs was the ALJ wanted to hear from consumer testimony. That's not always the case, but he really wanted to hear it. And so I interviewed hundreds of consumers who had bought the product and complained to the company about this. We conducted depositions in consumers' kitchens, in their basements, in their offices. And we learned that people bought these products for very personal reasons. One was a physician whose wife was dying of cancer. One was a woman who had an adult child with special needs, who had cognitive issues as well as autoimmune issues. And she thought she was spending her $39.95 on something to make her adult child healthier. So it really reminded me there are people behind all of these cases. We talk about consumer impression. Those are real people who have a right to the truth. And these are things, I don't have kids. You tell your 8-year-olds, don't quibble, don't lie, don't give me a half story. And yet there are businesses that do that. And I think that's the most important message that I learned from that water filtration device case. is that there are real people out there that we are representing when we go to court to try to vindicate their rights.
Wow. Wow. Again, we could talk about this all day long because I know there's so many other cases and so many other war stories that are incredible. But you've also been involved for a long time with the ABA, the antitrust section, which is where the Consumer Protection Merry Band has some presence as well. And I know you've spent a ton of time with the Janet Steiger Fellowship Project. And I think some of our audience might not know who she is. So first tell us, who is this amazing woman, Janet Steiger?
The late Janet Steiger was appointed by the first President Bush as the chairman of the FTC, and she was neither a lawyer nor an economist. And I am lucky enough that while she was still alive, I was able to face-to-face personally apologize to her for rolling my eyes when she got the job. Because I said, oh, come on. She had been the widow of a member of Congress. She was head of the Postal Rate Commission. But this was not an antitrust scholar. This was not a marketing expert. This was not an economist. No, she was simply the best manager I have ever seen in my entire work career. I remember one time sitting in a meeting and having my boss, the amazing Lee Peeler, ask her how she wanted us to proceed with something. And Chairman Steiger's answer was, listen, I set the goal. I tell you where the finish line is. But I trust experienced attorneys and litigators and policy people to come up with the best way to get there. She trusted her staff. She was a person who was bipartisan down to her very soul. I think the story that really did it for me, every year, as Daniel remembers, there's an FTC award ceremony. The chairman is allowed to give out a few special awards. And back then, this tells you how long ago it was, there was one fax machine at the FTC's headquarters, one fax machine at the satellite office. And there was a very nice man who was there under a sheltered workshop program for cognitively challenged adults, whose job it was to tear off the fax and to deliver it to the attorney or economist who needed it. And woe be unto you if Phil came running through the hallway on a mission to deliver the fax. We put ourselves up against the wall because he was going to knock us down. Nothing was going to stop Phil from getting there. And when it came time for Janet Steiger to give an award for who best represented the spirit of the FTC, the spirit of hard work and service and collegiality, she didn't give it to the general counsel or the deputy bureau director. She gave it to Phil. And there wasn't a dry eye in the house. And I think that says an awful lot about the kind of person Janet Steiger was.
I always regretted that I never got to meet Janet, and it was before my time at the agency because I've heard so many wonderful stories about her. But this then leads us to the Janet Steiger Fellowship Project.
Oh, I'm sorry. That was the question you asked me 10 minutes ago. I apologize.
First question was, I just want to know about her, but tell us about the project. What is it for law students?
It is sponsored by the ABA Antitrust Law Section, which is where I first met Amy, working on ABA projects. And each section of the ABA tries to take on a pro bono project. And this one was actually the brainchild of Bob Langer, who was the longtime head of consumer protection and antitrust for the state of Connecticut and had worked very closely. At the time Janet Steiger became chairman, there were some real rifts between the FTC staff and state AGs. And it was not pretty. And I remember Janet Steiger calling us in and saying, listen, we're different agencies. We have different statutes. We have different roles. But the moment I hear of any one of an FTC people, my troops, as she called us, treating a state AG or an AAG with disrespect or derision, she said, go find yourself another job. She kind of built that bridge that I think has been in place since then, since the early 90s, of the FTC staff and the state AG staff. Again, not always in agreement, but in my experience, getting along very well. Bob Langer came up with the idea, with the permission of Janet Steiger's relatives, her sister and her son, of setting up Steiger Fellows. This sets up a paid summer law clerkship with the consumer protection section of state attorneys general across the country. There have been 600 of them that have gone through the program. Where have they gone after that? A number of them have gone to big law firms. A number of them, one of them is the president of a major sports team. One of them was a Supreme Court clerk. Many, many of them have become the head of consumer protection and antitrust for their states. And it basically pays them not a lot, but at least a little something. And they spend the summer working on consumer protection and a little bit of antitrust cases for the state AGs. It's a really important foot in the door. I think this is all across the country, red states, blue states. I myself have thought about applying for the Hawaii Steiger Fellowship. Who wouldn't want that? But they really make an amazing contribution. And I am grateful to ABA leadership, Joanne Travis, who's the director, current and former chairs of the ABA section of antitrust law section, who have supported this. And I will give Bob Langer real credit that we now have 600 former Steiger Fellows who go to their job, again, whether in the public sector, in the private sector, or anywhere, go to their job, I think, much better educated and much better attorneys because their first job was with the state AG's office.
Well, we encourage our law student listeners to look into this. You can find out about it on the ABA Antitrust Section's website. And Leslie, I know you spend a lot of your own personal time doing this for many years, and you continue to do so. Thank you. Now, Leslie, I've heard there was a notable moment when you were at the FTC in your enforcement work when opposing counsel on one of your cases referred to you as Queen of the effing FTC. Now, I suspect that was not intended as a compliment, but from our perspective, it's an incredibly worthy title. But without naming names, can you give us the background of how and when this title was bestowed upon you?
Yeah, this was in a hotly contested case. There were cross appeals pending. And the idea was maybe this is a case that ought to be settled rather than go through the appellate process. And here's the interesting thing. You can probably tell over the past few minutes, I do have a very good memory for very strange details. But can you believe it? I do not remember what I did to earn that title. I think I was so honored to be called the Queen of the effing FTC that I think I got a little verklempt. I was so pleased that I forgot over the years what I did to do that.
I'm sure it was something worthy, though. I have no doubt. Now, Leslie, I know you've collected a good deal of FTC memorabilia over the years. Are there any sort of items you have in your collection that might be particularly noteworthy?
Yeah, I have a few bins of stuff. And let me make it clear, I do not take home things that were turned over pursuant to a civil investigative demand. I buy all of my stuff on eBay. And so I think my proudest, I am the owner of not one, but two Gutbusters. Speaking of unfairness, this actually started as a deception case. It said the Gutbuster basically was an exercise device from the 80s that said it would flatten your stomach. It basically lifted you up with a spring, which made it very easy to do sit-ups. And, the FTC sued under a deception theory that it did not flatten your stomach because what I learned, I was actually assigned the case because never having actually done a sit-up in my life, I think I was considered very impartial on the subject matter. But what our expert told us was that the benefit of a sit-up is the up. And if the spring is lifting you up, it's like doing a Stairmaster stair climbing on an escalator. So the FTC brought the case for that reason. However, in the course of investigations and getting ready for trial and everything like that, the FTC also learned of hundreds of injuries to consumers from the product. The spring stretched out over one's midsection. In many cases, the spring snapped, forming a jagged hook that then embedded itself in soft tissue, leaving jagged lacerations. And if you think I did not try out every one of those phrases, I was thrilled that the ALJ was in the fetal position after her opening statement. It caused serious physical injuries. So I still have the Gutbuster. Not a surprise, the vast majority of the injured consumers were male, but it busted something, but it sure wasn't the gut.
Okay, now let's turn to the final topic for today, the future of the FTC. So, look, I don't think it's a controversial take to say there is a good deal of turmoil at the moment for federal employees, and that, of course, includes FTC staff. And we are seeing a lot of long-tenured FTC employees leaving the agency. So, taking a look into your crystal ball, and I'm guessing that you may, in fact, own one, but that's another story. What do you think we should expect from the FTC for the next few years?
Well, I have a magic 8 ball, and the first thing I think the big picture thing at the Supreme Court is certainly the Humphreys executor case. The notion of bipartisanship, the FTC in 1915 was intentionally made up of 5 commissioners, only 3 of whom may be members of the same political party, and they can only, according to the statute, be fired for inefficiency, malfeasance, for bad conduct. Of course, the 2 Democratic commissioners were recently fired by the White House. This is not an issue just dealing with the FTC. There are a number of these agencies. But I think the role of this bipartisan administrative agency, this is the big question about how the Supreme Court is going to rule on that. I will say, I've said it probably 12 times already, I think the FTC works best in a bipartisan fashion. When there are people who come from the Republican side, from the Democratic side, from the independent side, come as former general counsels of companies, come as former economics professors, when they reflect many different ideas and experiences, I think that's when the FTC works best. I think the big picture bad news, I would suggest, and again, speaking just for myself, is what I perceive to be attack on the integrity of civil servant. I think there has been encouraging a picture that those of us who devote ourselves to a career in public service are Marge Simpson's sisters who work at the DMV, who have our tote bags packed at 3:59. That's just not who I worked with at the FTC, at the FDA, at the Securities and Exchange Commission, at any of the other federal agencies. Despite what the head of the Office of Management and Budget said, we are not villains. So I think that is a really troubling point. Certainly attacks on law firms, of course, very troubling. And my particular interests are concerns about attacks on the integrity of civil servants and also about the role of bipartisanship, which I think is very important.
Lesley, we can't thank you enough for being so generous with your time and very candid with your answers. I think particularly what you just said is incredibly important and food for thought.
I worry when it's interesting. Yeah. Thanks, Amy.
To be clear, the sisters are Patty and Selma.
Thank you, Pat. The Bouviers. Yes.
But with that, again, we can't thank you enough. We hope you'll come back and join us again. I think we could have you every time, and our audience would just love you. But thank you so much for joining us for this special edition, part 2 of You Have Lesley Fair Notice series at Ad Nauseam. We'll see you next time.
Thank you, Amy, Daniel, and Leslie. If you have any questions for Amy, Daniel, or Leslie, their contact information is in the show notes. For more information on the latest developments in ad law, visit our Adventures in Law blog at www.adventures-in-law.com. And check out all of our Ad Nauseam episodes by subscribing to Baker Hosts wherever you get your podcasts. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.